Can I hand this to your... I'm sorry.
Before we move on to the next line of questioning, I think it's been about an hour.
That's fine. You want to take a 5-minute break? If we can keep it pretty close, then we can get out here on time, otherwise we're going to go long.
We are going off the record. The time on the monitor is 2:14 p.m. We are back on the record. The time on the monitor is 2:26 p.m. You may proceed. Thank you.
Okay, let me show you... Well, let me just... So do you believe that Ms. Duval was stigmatized when you included the reference to Munchausen's by proxy in the court reports?
Objection vague and ambiguous.
Do you understand the question?
Stigmatized by who?
You, when you referred to her as being possible Munchausen's by proxy.
I don't believe so.
Why or why not?
Because it was included in there to indicate that further assessment was needed for that, as well as other issues, and also to do an evaluation of the family.
Do you find that the reference to possible Munchausen's by proxy was a fact or an opinion?
Objection. Calls for legal conclusion. And calls for expert opinion.
It was a statement in reference to the upfront assessment results that were provided.
So it was a fact.
It was a statement.
In your mind, was the upfront assessment that made reference to a mental health exam to rule out Munchausen's by proxy a fact or an opinion?
It was an assessment. And with the information in that assessment, I provided that information to court for them to order further assessment.
And everywhere you put possible Munchausen's by proxy, you made sure to note it was someone else's opinion that a further examination was required, right?
Objection vague and ambiguous.
Do you understand?
Assumes facts.
Do you understand the question?
In the discussions of Munchausen's by proxy in the reports, within that same context, I also mentioned the upfront assessment and attached it for the court's review. That's it.
In your mind, when you wrote the joint disposition report and you made reference to the Munchausen's by proxy, was that a fact?
Well, it's the same answer that I had previously indicated. It was a statement of information that was provided in the upfront assessment, which needed further assessment, which is why it was in there to request further assessment.
And to your knowledge, did you qualify the reference to Munchausen's by proxy by indicating there was a need for further assessment in the joint disposition report?
Can you repeat the question?
Can you read it back?
And to your knowledge, did you qualify the reference to Munchausen by proxy by indicating there was a need for further assessment in the joint disposition report?
Objection document speaks for itself.
You can answer the question.
I felt like the information was qualified.
I'm sorry, was qualified.
I felt like it was.
Okay. You would not leave that information in the report in an unqualified fashion, correct?
I don't know whether or not, I can't say I would or would not, but I can say that I felt like it was indicated appropriately in the report.
And you weren't trying to say that Ms. Duval suffered Munchausen's by proxy, right?
I never made that statement in the report.
Correct. And all I'm suggesting is that when you included the reference to Munchausen's by proxy in the report, you were not trying to indicate that she suffered this mental illness, right?
I was not making that statement in the report that she suffered from that mental illness.
Right. You were just documenting the fact that somebody else had alluded to it, right?
I was documenting that information that was indicated in the upfront assessment.
And did you speak to any of her physicians about whether or not she suffered this condition?
Did I speak with, no, I did not.
Did you have the ability to contact her physicians to discuss this concern with them?
Likely.
Is that a yes?
It's a likely,
What does likely mean?
perhaps.
Okay, you're saying there's odds you couldn't speak to her doctors?
And I'm going to do a belated objection that the question assumes facts, not an evidence.
Okay. Did Ms. Duvall have doctors to your knowledge?
I don't recall.
Do you know Victoria Shealy?
I know of the name.
Do you know her personally?
I've never met her.
Never met her?
Never met her.
Do you work in the same office?
We do not.
In 2010, did you work in the same office?
We did not.
Has she ever faxed you anything?
I don't recall if she ever faxed me anything.
Okay. Let me hand to you what we've marked as exhibit number 17. Please hand it to your attorney.
Thanks. Do you have an extra copy of this that I could look
I
at?
don't think we do, but this will be quick. So let me ask you this. This says Civil Rights Report of Investigation, Second Amendment, correct?
Correct.
And if you look at the boxes, it's dated August 2nd, 2010, correct?
Date report completed August 2nd, yes.
Okay. You have never seen this document before today, correct?
I don't recall ever seeing this document.
Okay, let me rephrase the question. Between August 2010 and today, you have never reviewed the Civil Rights Report of Investigation, Second Amendment, correct?
I don't recall ever reviewing this report.
That would be yes. The answer to the question is yes.
Repeat the question?
Sure. Between August 1st, 2010 and today, you have never before seen the Civil Rights Report of Investigation, Second Amendment, correct?
I can't say yes or no if I've seen it. I've never reviewed it.
Was it sent to you, to your knowledge?
It was never sent to me.
Let's rephrase that question. Between August 1st, 2010 and today's date, was the Civil Rights Report of Investigation, Second Amendment ever sent to you, to your knowledge?
To my knowledge, it was never sent to me.
Okay, so you've never had a chance to read and read this document before right now.
I've never read it.
Let me ask you to turn to the last page.
Page 14 or the page before that?
I'm sorry, page 13, thank you. Let me draw your attention to recommendations on page 13. Do you see that?
Yes.
Please read that paragraph. Let me just read it to you. The investigation revealed SOI Shealy would benefit from cultural sensitivity training in addition to training in documentation her observations in an objective and factual manner. Do you see that?
Yes.
Have you ever discussed this finding with Ms. Shealy?
I have not.
Okay, let's continue. SOI Nelson would benefit from training in accurate and appropriate court report documentation. Do you see that?
Yes.
Have you ever been asked to attend any form of training regarding accurate and appropriate court report documentation?
I don't recall being asked to attend a training on that.
Do you know, as a result of this civil rights investigation, if you were asked to undergo any additional training of any kind?
I don't recall if there was any specific training that was a result of this investigation.
It's fair to say, Ms. Nelson, that you were never contacted by a superior and informed that the Civil Rights Division had sustained a violation of Ms. Duvall's rights by you and directed that you would undergo further training, correct?
Objection compound.
Can you repeat that?
Let's just read it back.
It's fair to say, Ms. Nelson, that you were never contacted by a superior and informed that the Civil Rights Division has sustained a violation of Ms. Duvall's rights by you and indicated you should undergo further training, right?
I don't recall ever being asked to undergo any additional training as a result of this investigation.
Got it. And let's just be clear, because your attorney admitted an objection about being compound. First, we'll break it apart. No superior has ever contacted you, strike that. No superior has ever contacted you and informed you that you shall undergo additional training as a result of Ms. Duvall's civil rights complaint, correct?
I don't recall ever being contacted by a superior.
You can just say yes, it's true.
Well, I don't recall ever being contacted by a superior to undergo any additional training.
So to the best of your recollection, at no time has a superior contacted you and told you that as a result of Ms. Duvall's civil rights investigation, you shall undergo additional training.
I don't believe so.
That would be correct.
Okay, I don't believe so.
Okay. Have you ever heard of a woman named Lynn Condon?
The name doesn't sound familiar to me.
Do you know who she is?
Well, the name doesn't sound familiar to me.
Okay.
So,
You can say no. You don't know who she is.
no.
Do you know who the Employees Relations Manager for your department is?
I do not know that person.
Do you know what an Employee Relations Manager is?
I don't know exactly what they do.
Is there one to your knowledge?
I do not have that information. I don't
Okay.
know.
Let me draw your attention to exhibit number 18.
Can I get that one back with the clip on it, please? Thank you very much. Thank you so much.
This is actually Catherine's deposition, whether we all want to admit it or not.
I'm sorry to be so bossy.
She's just doing her job.
Just make review.
Okay, your attorney's had a chance to review it. This is the Civil Rights Report of Investigation Addendum, correct?
Correct.
And this is dated September 9, 2010, correct?
Correct.
And you have never seen this document before today, correct?
I don't recall ever seeing this document before today.
We draw our attention to page 3, where it says conclusions. Let me draw your attention to the last full paragraph on the page. Let me know when you're there.
I'm there.
Please take a moment and review it to yourself. Are you ready?
Yes.
Okay. It says, the investigation revealed C.P. Duvall was treated differently in the receipt of DCFS services because she is a member of the protected class disability. Do you see that?
Yes.
And you have no information to agree or disagree with that statement, correct? Is that question clear to you?
Yeah, I'm just reading the sentence over.
Can you reread the question for me?
And you have no information to agree or disagree with that statement, correct?
Well, it's stating that that's what they felt from their investigation, so I can't say
Right.
that it's true or false.
I'm asking you based on your knowledge. Based on your knowledge, you could not confirm nor deny that Ms. Duvall is disabled because your testimony was she never informed you she was disabled, correct?
I'll say correct. I was never informed that there was any disability.
Okay. Then it says, the CP was held responsible for neglecting, abusing, and harming her son by withholding food from him because she was perceived by the SOLs as being impaired by MSBP. Let's take that slowly, but you've heard that statement, correct?
I've read it right here.
And you understand the SOIs to include you as a subject of investigation, correct?
Correct.
And you understand MSBP to be Munchausen syndrome by proxy, right?
Correct.
Okay. So you understand that the statement, the investigating civil rights county employee determined that you violated Ms. Duvall's rights by suggesting she suffered possible Munchausen's by proxy, which further was supporting a perception that she was withholding food from her child. Do you understand that to be the conclusion of the report?
Can I have that restated?
Sure. The investigator is saying here that, number one, the social workers, which includes you, held Ms. Duvall responsible for harming, neglecting, and abusing her son because you perceived Ms. Duvall as suffering Munchausen's by proxy. Do you understand that?
Well, this states that Ms. Duvall was held responsible for neglecting, abusing, and harming her son by withholding food because the social workers perceived her to have MSBP.
Yes, ma'am. You understand that was the conclusion of the investigating civil rights person, right?
That was Michelle Hochstein's conclusion.
You have never seen this conclusion before today, correct?
I've never read it before today.
Okay. So, you disagree with that conclusion, correct?
Correct.
And you never used the Munchausen's by proxy consideration as a basis to make recommendations in Ms. Duvall's case, correct?
Correct.
Did you ever conclude that Ms. Duvall's son was of low weight because his mother was denying him food?
Can you repeat that?
In your estimation, why was Ms. Duvall's son of low weight?
Well, that would be based on, I think, more than one factor.
Okay. Based on your understanding, what factors are there?
And I'm going to make an objection to the extent that it seeks a medical opinion. You can respond. And also calls for a narrative.
Well, my assessment was that some of the foods that he required more of, he was not receiving. And one of the conclusions that was drawn was with him being in her care and some of the information that was provided by the doctors, that there was concern in regards to him being provided proper nutrition.
That was Dr. Yim you're speaking of?
I can't state exactly which doctor it was. I don't recall the specific doctor.
But do you recall speaking to Dr. Yim?
I recall medical records or things like that.
Do you ever recall actually speaking to Dr. Yim?
I do not recall.
But you would never document in your own records having a conversation with the physician that never occurred, correct?
I would not falsely document any records.
I understand, but you would never, I didn't say falsely, I just said you would never document a conversation with a physician in your records that never occurred, correct?
I would not document a conversation if it did not occur.
And normally when you call a physician, before you can speak to them, you have to have a HIPAA release, correct?
Correct.
And if you're going to talk to a physician, you would normally give them the HIPAA so that they can talk to you, correct?
Objection vague and ambiguous.
You understand the question?
Well-
Let me rephrase it and make it simpler.
Yeah.
Ma'am, would you agree it's against the law for a physician to speak to you about a patient unless the physician has a written release of medical information before discussing the patient's treatment with you?
You're asking me if that's legal for a doctor to speak with me without release of information?
Yes, ma'am.
Objection calls for legal conclusion.
Let me rephrase it again, make it even simpler.
Okay.
Do you believe a doctor can talk to you about his or her patient before you provide the doctor a medical release authorizing the doctor to give the information about that patient to you?
Objection speculation.
I think in general, the doctors will request a release of information before they can provide us information in regards to their patient.
That's your experience?
In most situations, yes.
Okay. And with regard to Ms. Duvall's case, your expectation is that you would offer a HIPAA before a treating provider would give you any medical information about the patient, right?
Objection vague and ambiguous.
I would anticipate that a doctor may request a release of information prior to providing me any information in regards to their client.
Okay. Let me draw your attention to page 4 of 4, the last page of the document in front of you, Exhibit 18. Let me draw your attention to the last line. I'll read it to you. SOI Nelson would benefit from training in accurate and appropriate court reporting court report documentation, excuse me. Let me do that again. SOI Nelson would benefit from training in accurate and appropriate court report documentation. Do you see that?
Yes, I do.
Have you ever been asked to undergo any training in accurate and appropriate court report documentation?
Objection vague and ambiguous as to time.
Between August 1st, 2010 and today's date, have you ever been asked to undergo any training regarding accurate and appropriate court reporting documentation?
I'm trying to recall all of the trainings that have been completed and when they were done.
Let me rephrase
I
the question.
don't recall being asked to complete court report writing training.
Thank you, and let me be more specific. It's certainly true, ma'am. To your knowledge, as a result of the Duvall complaint, you have never been requested to undergo training to ensure that you're providing accurate and appropriate court report documentation, correct?
I don't recall being asked to do any additional training for court report documentation.
Okay, let me draw your attention back to our conversations earlier about your RA. Is his name Steve Sanders, S-A-N-D-E-R-S? Is that the name?
Yes.
And that was the person you spoke to?
Yes.
Did you give any information during the meeting with Mr. Sanders that was calculated to get the civil rights investigators to determine that you did not violate Ms. Duvall's civil rights?
Objection vague and ambiguous.
Do you understand the question?
No.
Did you provide any information to Mr. Sanders during the meeting we've already discussed to persuade the civil rights investigators that you did not violate Lena Duvall's civil rights?
Did I provide, can you repeat it one more time?
Could you read the question back, Madam Reporter?
Did you provide any information to Mr. Sanders during the meeting we've already discussed to persuade the civil rights investigators that you did not violate Lena Duvall's civil rights?
I don't recall.
Did you ever confuse Ms. Duvall as a mother that is medically knowledgeable and well-informed about her son's condition with a person suffering Munchausen's hypoxia disorder?
Objection vague and ambiguous.
Do you understand the question?
Can you restate it?
Let's have it reread.
Did you ever confuse Ms. Duvall as a mother that is medically knowledgeable and well-informed about her son's condition with a person suffering from Munchausen's by proxy disorder?
Objection calls for an expert opinion. Vague and ambiguous.
I can't state that I confused her as either. I can say that both of those statements are individual, and probably would need to both be verified.
Let me have you please read exhibit number 19, which I'm handing to the court reporter, and she will give to your attorney. Actually, you know what? Let's hold that for 1 second.
Okay.
Thank you. Let's go back to talking about any termination discussions that you had with the County of Los Angeles. It's true, ma'am, that you've never been advised that the conduct of including the Munchausen's by proxy reference in Ms. Duvall's court report subject you to termination with the County of Los Angeles, correct?
I don't recall ever being advised of that.
Right. There's no such discussion so far as you know.
As far as I know, I've never been advised of that.
You've read no documents that suggest that your conduct in including a Munchausen's by proxy reference in Ms. Duvall's court record.
Sorry, I lost the question.
Sorry.
As far as you know.
As far as you know, let's just restart the question. So far as you know, no documents exist that suggest your conduct in including a Munchausen's by proxy reference in Ms. Duvall's court records subjects you to a discipline path which may result in termination, correct?
I don't recall reading that anywhere.
Right. You've never seen a document that suggests that, right?
I don't recall reading that anywhere.
You're suggesting reading it, just a nuance we need to clear up. Have you ever seen such a document?
I don't recall ever seeing it anywhere, so I can't say, yes, I've read it someplace.
I understand, and we're just doing it step by step since you're answering that way. You've never seen nor reviewed any document that said your conduct in including a Munchausen's by proxy reference concerning Ms. Duvall in court records would subject you to termination.
I don't recall seeing that anywhere.
Okay. Please take a look at Exhibit 19, hand it to your attorney, and let me know when you're ready to proceed.
Thank you.
All right, you can just take 2 seconds. Let's just take a 2-minute break while we do that. Off the record.
We are going off the record. The time on the monitor is 2:53 p.m. We are back on the record. The time on the monitor is 2:54 p.m.
Ms. Nelson, you've had a chance to read Exhibit 19, correct?
I'm currently reviewing it.
Okay. Just take your time. Let us know when you're done.
Okay, I've read it.
Have you ever seen Exhibit 19 before?
I don't recall ever seeing this document.
This is news to you.
Yes.
You don't know who Lynn Condon is, do you?
No.
You've never met Lynn Condon, have you?
No.
You've never discussed this case with Lynn Condon, have you?
No.
You have no idea what Ms. Condon knows about this case, do you?
No.